I don't know what to say anymore. Because one minute, me and Michelle agree upon a bunch of other stuff and everything's going good. And then,
And we're off. Richard opens the hearing with a classic jab blaming Michelle's lawyer for stirring the pot. But is it really that simple? Spoiler, no.
all of a sudden, her lawyer's got to poke her nose in it and get involved and then cost her more money.
We will go on the record in the matter 24 FA 78, in re the marriage of Michelle Phelps and Richard Chanel Jr. Appearances are we have both parties appearing in person. Ms. Phelps appears with her counsel, Kathleen Jonas. Mr. Chanel appears pro se. We're set today in this matter on the motion hearing, a motion for sanctions. Ms. Jonas, I believe this is your motion.
It is, Your Honor. We were here on May 1st in front of the commissioner, and there is an order on motion to compel and an order on motion for contempt. And on the motion for to compel, the respondent agreed, and it was ordered that he provide answers to our interrogatories and provide documents that we had requested on March 3rd. And that date was set to be May 9th, that he would have that information to us. That did not happen.
Let's unpack this. Richard was legally ordered to provide answers and documents by May 9th. That's not optional, it's mandatory. Ignoring this puts him on a fast track to being held in contempt.
And that's when we then filed our motion that we are here today on. And then there was also an order, order on the motion for contempt. In November, Mr. Chanel agreed and was ordered to keep the mortgage payments current, his car, and the Royal Credit Union. The last payment was in January. My client had gotten a letter from the lender saying if it wasn't brought current by June 6th, they would start a foreclosure. And so the court held open a finding of contempt. And that also, the date was set that he would bring that current by May 9th. And I'll have to add that this was by stipulation in the court with the court commissioner. That payment had not been brought current, and thus we filed the motion that we are here on today, requesting that it be found in contempt and that sanctions be entered. In addition, at the first hearing, we asked for $1,000 in attorney's fees.
Things just escalated. We're talking foreclosure threats. If the mortgage isn't paid, this isn't just legal back and forth, it's about keeping a roof over someone's head.
We agreed to hold that in abeyance as a incentive for Mr. Chanel to comply by bringing the payments current and answering the discovery request, which he did not do. So we would ask that the court would enter that request. And then we also requested $1,000 for today for having to bring this motion because discovery had not been provided. And at the time the motion was filed, the payments had not been brought current. Now, about 2 weeks ago, Mr. Chanel did bring the mortgage current. My understanding, it is current as of June 4th, which is when the payment was due. Nevertheless, we had filed our motion and we are here. We emailed him the motion, we mailed him the motion, attempted service. He had already left for his job in Montana, but did know about today's hearing, and that's why he is here. Today in the hallway.
So, Richard handed over key financial authorizations, literally in the hallway before the hearing. That's not preparation, it's a last-minute Hail Mary. Courts don't run on hallway handoffs, folks.
He did provide me signed authorizations for his retirement account and a signed financial authorization, which I had requested. He hasn't filled out the financial disclosure statement as is required by statute in order for the final hearing to be complete. And he provided me pay stubs. I believe, I haven't had a chance to look at them because he just gave them to me. But I believe what he said is they go back to the beginning of the year, which will be helpful. Just a little background, these folks have not filed the joint income tax return. Was it starting in 22? You didn't do it in 22? For sure, 2023 and 2024. And I don't have W-2s. Mr. Chanel indicated today that he can get those, and I've asked him to do so. Even though he signed the retirement authorization, he has told me that it's Wilson McShane. He's told me that, but he hasn't, provided any written answers to anything. So that is where we stand on that. We would like him to be found in contempt, keeping in mind that he did bring the mortgage payment current, but we've had to attend 2 in-person hearings on this. And that's,
Richard's defense. We were working things out until lawyers got involved. Translation. He ignored court orders and hoped everything would just magically resolve itself. Classic miscalculation.
Part of the reason the attorney's fees are so high is Ms. Phelps is paying me to drive here and have a court hearing and drive back, in addition to drafting our motions and affidavits and so on. And it's expensive to do this in order to try to get Mr. Chanel's compliance. Also today, I would ask that the court would set this for a trial date because we're getting nowhere. So we should have a trial date.
Ms. Jonas, would you think that it would be a half day or a full day?
I think a half a day should do it. Yeah.
All right, Mr. Chanel, your response?
I don't know what to say anymore. Because one minute, me and Michelle agree upon a bunch of other stuff and everything's going good. And then all of a sudden, her lawyer's got to poke her nose in it and get involved and then cost her more money. So it's like, one minute it's like we were going to make it work, one minute we're not. So why do you think I procrastinated that? That's why.
So, Ms. Jonas, what are you still waiting for the interrogatories and documents?
We have no written answers, none.
Didn't say anything about mailing it back in.
And they are abbreviated. I did not send out, like a lot of attorneys will exchange. I think there's 13 questions. And the same on the production of documents. We haven't received any documents except we did get now pay stubs, and he signed the authorizations for financial information and for retirement. But again, I haven't, received any documentation on that, like any reports, values, anything like that. We have no knowledge and no financial disclosure statement.
All right. Okay, Mr. Chanel, do you understand or do you know what questions she's asking?
Yes, I understand. But the reason why she didn't get it is because, Shelley, we were going to work on it. It wasn't supposed to come this far. And this was just recently. And then all of a sudden, boom. So that's why she didn't get them. I mean, they're signed. They've been signed. They just...
Where are they?
She has them. I didn't know I was supposed to mail them to her.
Oh, wait.
I had to give them to you when we came to court again.
He showed me he signed a blank financial disclosure statement that I sent him. He signed it and dated it. It's not filled out.
It says signed. I didn't know you got to fill it out. And she already had it all filled out.
Signing a blank financial disclosure form and calling it a day. That's like turning in a test with just your name on it. Legally, the judge knows it.
And so, Mr. Chanel, That's the law. The
Oh, I
law
know.
is you must do the financial disclosure statement, not just for Ms. Jonas, but for the court, because I need that
And
document.
when I seen it though, when I looked at it, it was already, Shelley had everything filled out on it.
You have a copy of it here?
This is what she had all written down here, party 1, party 2.
We sent him Ms. Phelps' financial disclosure
And it
statement.
had mine on it too.
And Mr. Chanel, in looking over the amounts and the numbers and the things that Ms.
Yes.
Phelps has put on there, are they accurate?
Yes, I mean, I had, like, Shelley always took care of like our financial stuff, so she had access to everything. So, and as far as everything else on here, it is accurate. That I know of.
Well, then for the record, the court will use and accept what Ms. Phelps has put down. So if there's anything that is not accurate, unfortunately, it's not going to come into evidence.
And the only thing that was on here that ain't on there is her current balance on her vehicle, and that's, I mean, that should have been both of ours. It's in both our names.
And Ms. Jonas, did you say you filed a financial disclosure? Yes, you did.
Okay.
All right, then in looking at it, Ms. Jonas, do you have any objection to any of the court using the information that's provided by Ms. Phelps?
No,
Except for
with
maybe a
the
more accurate income because it says approximately.
exactly the income was an estimate on her part. Now that we have pay stubs, we can define that better.
Richard didn't submit his own numbers. The court's just going to use Michelle's. That's what happens when you skip your homework and expect your ex to handle the paperwork.
Let's see. The retirements, his retirements are the thing that we have no value. Hopefully we can find that out.
Now that you have the authorization, you should be able to access that. And then you have his income, so you should be able to access that. Is there anything else in the interrogatories that are specifically related to the financials?
Just let me look here a moment. I don't know that I will be able to define the benefits that he receives through his employment. And they could be things that wouldn't show on his paycheck, such as use of a company truck, cell phone, per diem.
Do you have an HR representative?
Yeah. Yep.
He could sign an authorization for release.
Okay.
And is that all the specific information?
Do you think he is?
Or the court can order it. I could just order that it's released to you,
Okay.
because that can be done, you know, probably a lot sooner.
Yes. Other than that, if he's agreeable to her financial, those are the ones with the question mark on it.
And do you have the copy right there, Mr. Chanel, of that financial disclosure?
Of hers, yes.
Yes. And do you only have that one copy?
Yep.
So what I'm going to do is I'm going to print out what I have filed, and you're going to look it over again one last time, Mr. Chanel, and you're going to sign it. And then other than the few things that you just received today, like with the retirement and all of that, Ms. Jonas, everything else will be what the court will use as the numbers, even if it is not accurate and it goes against Mr. Chanel's favor.
I don't want to jump ahead, but there is another issue about the use and occupancy
I was going to say about the house and the girlfriend.
and the sale and so on,
Okay.
that we are requesting. That's, he's not there, the girlfriend is. In her affidavit, my client asked that Mr. Chanel would have his girlfriend removed and we would get a court order. That's why we're in front of.
And now the girlfriend enters the chat. She's living in the marital home, and Michelle wants her out. Add property division, occupancy rights, and buyouts to the fire. This just got real.
In front of you today, to sell the house. Now, in discussions outside the courtroom, Mr. Chanel indicated that he wanted to keep the house and buy out my client, and she wouldn't have any objection to that. But, you know, he's got to participate. I didn't bring it with, but I have a proposed marital settlement agreement. And I would like to, you know, make that proposal. Just because he wants to do that doesn't mean that I suppose we're going to agree on a buyout. But we're open to that. But did you still want back in the house? So are you withdrawing that?
We got caught up in agreement and.
So you're okay with withdrawing that part of your motion?
Yep.
So Ms. Phelps is withdrawing that part of her motion then about occupancy reverting to her and for sale of the house.
All right. Okay. And so, Mr. Chanel, it sounds like Ms. Phelps and Ms. Jonas are willing to negotiate and talk about the house as being part of your award in the divorce. Are you here in Wisconsin a lot, or are you?
Yeah,
Not.
I'm only out in Montana for a few months this year and I'm not supposed to be out there anymore. So typically I just stay working in the metro area.
Okay, so you would have time to be able to meet with Ms. Jonas and go over discussions with regards to any resolution, and then if a resolution is reached?
Yeah, as long as I'm home. I mean, they knew I was taking off from Montana, and it's.
So what we can do today is I can set the matter for a half-day contested trial and give enough time for Mr. Chanel to be able to meet with Ms. Jonas and Ms. Phelps and to see if they can hash this out and sign a marital settlement agreement. My first available date is September 2nd at 1 o'clock.
That works on my calendar.
All right, we'll schedule it for September 2nd at 1 o'clock. If the matter resolves, Mr. Chanel and Ms. Phelps, and you're able to reach a marital settlement agreement, then you won't need to be here in person. We can handle your divorce and everything by telephone or by video. Okay? But that's only if you're able to reach an agreement. Otherwise, we'll have that contested hearing on September 2nd, starting at 1 for the rest of the afternoon. As it relates to the issue of contempt,
The judge finds Richard and hits pause on punishment. Why? Because there's still a shot at settlement. But if they can't agree by September 2nd, it's game on in court.
I do find that you are in contempt. You did violate the commissioner's order as it relates to the sanctions. I I'm going to hold that in abeyance as well, Ms. Jonas, because perhaps that could be something that you discuss with regards to resolving the matter.
Okay.
And I can take that up on September 2nd at that time if it's still contested, or it could be part of the resolution. Anything else, Ms. Jonas?
Anything else? That should do it for today, Your Honor. Thank you.
Anything from you, Mr. Chanel?
I gotta sign this one.
Yeah, sign that one on where, turn it to the back and sign right under where Ms. Phelps signed. And then you can bring it up here to the clerk and we should be good to go. All right. And I think that's all. Thank you.